Um, Here's the important motion today, and that is the decision that I'm going to indicate for the record, Jensen 1 and Jensen 2. State versus Jensen, 299, Wisconsin 2nd, 267. And State versus Jensen, 331, Wisconsin 2nd, 440. They're both identical as to the letter. And they ruled that the letter was testimonial. And they both ruled that the statements made by Julie to Kossman, who was a police officer for Pleasant Prairie, including the letter addressed to the police, are testimonial. So that letter, those statements, it's not coming in at all. I'm not the Supreme Court. I'm not the Court of Appeals. This is the law of the land. It's not coming in. But all the other non-testimonial statements, and the testimony, it was in the first trial. It says here, the statements Julie made to her neighbor, it talks about Wojt, W-O-J-T, her son's teacher, DeFazio, all those non-testimonial statements that are in Jensen 2, which is 331 Wisconsin 2nd, 440. They're coming in. That's a distinction. And that's the law, and that's what's going to happen at the trial. And if anybody does anything different, they'll pay the consequences. And
now I want to ask you about one more conversation. So you had told us in detail about the conversation you had with Julie Jensen on November 25th of 1998. During that conversation, obviously you heard some disturbing things. Did you ask Ms. Jensen whether she had told anybody else her concerns?
Yes, I asked her if she told anyone else, and she said she had told a police officer at Pleasant Prairie, that a friend that she knew.
Just strike as unresponsive and hearsay.
overruled, go ahead.
And from the motion and limine, Judge.
Overruled, go ahead. Right now?
I would like to, Judge, but before we do that, can I just put an objection on the record?
Sure.
Okay, so when Ms. DeFazio was testifying, I objected and said it was based upon the motion and limine because she had testified that Julie told her that she had told police officers about being in danger or about telling police officers about thinking Mark was going to kill her. And I believe that is outside of, I think that's inconsistent with the ruling this court made that no statements to law enforcement and the letter were not coming in. So that's why I made that objection.